Hi, my name is Amanda Rocha. I am an estate planning and probate attorney in California. Today we are going to discuss trust protectors. Before I get into that, I want to give you my contact information. You can reach out to me about estate planning or probate matters in California. We can create an estate plan for you. I can open a probate case for you if you're in my area, or we can just discuss these matters in general if you have any questions. You can find me on my website at www.amandarocalaw.com. You can comment down below if this platform allows you to do that, or you can find me on social media at Amanda Rocha Law. So today we are going to discuss trust protectors thanks to a podcast listener named Sarah who messaged me on Facebook and asked if I could discuss what is a trust protector and what do they do, because it is very confusing. And if you read any information online, you'll know that every state has different rules and laws about not just trust protectors, but everything to do with estate planning and probate. And not only that, but every website has a little bit different information on it, and it can be very confusing. Oftentimes, when I create an estate plan for my clients, I don't bring up trust protectors because most estate plans don't seem to need them, but it really is going to be fact specific. So don't take my word for most don't need them. If you're going to create your own, it's a whole different ballgame. Most of the estate plans that I have had do not need them, but that does not mean that most everywhere do not need them. So take that with a grain of salt. But first of all, what's a trust protector? So a trust protector is a third-party person who is not a beneficiary and has no interest in your trust. They are not the trustee. And so this person is usually someone who's there to resolve disputes between a trustee or trustees and the beneficiaries, or has the ultimate power to make decisions that the trustee doesn't have, such as moving the location of the trust. So if you've got a trust based out of California because that is where the person who created the trust, the grantor, lived, but now they've moved to Arizona and they passed away and all of the beneficiaries live in Arizona. Maybe the trustee doesn't have the power to move that, but the trust protector could. They're also able to make all sorts of different changes, changing the amount that a beneficiary would receive, for example, or make other changes to the trust to fit the current needs of the trust that maybe the trustee didn't have the capacity to make those powers, either because the trustee is also a beneficiary or the trustee is a little too close to the situation. So I'm going to give you a couple of examples of why and how this might be important. So a common example is the trustee is also a beneficiary. Let's say a person creates a living trust and during their lifetime they are the trustee themselves and their beneficiaries are their 2 children or 3 children. Once they pass away, they have named their successor trustee as one of those children. If there is a dispute amongst the children who are also the beneficiaries, generally disputes are resolved in a few ways. One is a majority of the beneficiaries agree. 2, a unanimous vote from the beneficiaries have to make a change, like as to who is the trustee or other little changes. Or 3, you can name a court of law. So this gives you a separate option where you can name a trust protector, another person to basically either make that decision outright or just break the tie if they have to do that. So a trustee can weigh in on disputes, or if you want to use someone as a trustee to make general distributions and you feel as if that person has the ability to follow the rules of the trust and understand what their duties are as a trustee, but they don't necessarily, you don't want them to have the power to make changes to the trust, you can have a trust protector make those changes, someone who's uninvolved and maybe has a little bit more capacity for making big decisions like this. So another option would be, again, we'll use the family where there's 3 children, one of them is the trustee. perhaps the children are in their young 20s when something happens, and they may not understand fully the ramifications of changing things in the trust, such as amounts given to people, or where the trust needs to be located, or, adding and removing property or subtrusts. Naming a trust protector might assist them in a way that would give them additional knowledge that they don't have as non-attorneys or fiduciaries. So that brings me to the next point, which is who can be a trust protector. It can really be anyone who has the capacity to be a trustee. So someone over the age of 18 who has mental capacity to make legal decisions. But it's recommended that it's a neutral third party, and some people recommend that it's a fiduciary or a lawyer who is named as the trust protector. I don't think that that's always necessary. It's going to depend really on what you are asking the trust protector to do. So how do you name a trust protector in your trust? You need to have very specific rules outlined in your trust as to what they are allowed to do and what they're not allowed to do. Otherwise, when it becomes too ambiguous, there will be arguments, and it creates a situation that is ripe for litigation, and you don't want that in your estate. You want your estate to be carried out seamlessly, and you want to try and avoid litigation, which is the main reason why you have a trust protector, is to avoid situations rising to the level of litigation. So you want to make sure that what they're allowed to do is very clear. It's still a complicated matter. I could talk about this for an additional hour. However, I'm going to allow you to reach out to me if you have specific questions. You can find me on my website at amandarocalaw.com. You can comment down below if this platform allows you to do that. Or you can follow on my social media, send me a direct message that way, at Amanda Rocha Law. Thank you.